and gentlemen, welcome back for another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Yardwan, joined as always by my co-host, the great and talented Julio Vela. JV, what's up, man?
Feeling good, feeling great. Not looking as good as you.
Well, I lost my razor this week, so I haven't found it. Still haven't found it.
It looks good. It's a little, you know, it reminds me of Wolverine. Who's the actor that plays that? Who's the guy?
Hugh Jackman.
Hugh Jackman.
I just need to get to the gym a little.
It's Hugh Jackman.
Then you can start calling me Hugh Jackman. I'll give you that once I get a little further down the workout routine. I did run today though.
I saw that.
So,
I saw that. It's not real if you don't
but
tag
I was
yourself.
taking crap from Andrew Wright. Don't give me crap, man.
Did y'all see his post on Andrew Wright where he posed as a Union soldier? Did you see that?
Before we can talk about that, but let's bring our guests in so they can join the conversation. We are joined this week, ladies and gentlemen, by a returning guest. We've conned him into coming back at least 5 times now, I think. Sean Buckley, thanks for coming back again.
Thanks, Jimmy, for having me.
Yeah, well,
it's always a pleasure.
I think despite your better judgment, you keep coming back. And
I'm a glutton for punishment.
You are. And first time appear on this show, long-time observer from the outside, the man truly behind the Russian collusion investigation, Gary Tabakman.
Oh, it's an absolute pleasure to be here, man. And
yeah,
I've watched
glad
for
to
a while,
have you.
and I'm really honored.
You're like a lurker. Right? That's what you've been. And now,
I'm in the background, and
now you've come on the show.
And I'm finally here. Yeah, I appreciate you having me.
No, absolutely.
A lurker is better than a creeper.
That's true. There is no doubt about that. Although,
very different spectrums.
Yeah.
Thanks for that,
Sean. Or a peeper. You know, want to go about it that way. But yeah, getting back to our good friend Andrew Wright, I made a nice little post about him because that's what a lot of spare time, no babysitter, and fun with Photoshop will do on Friday night.
If someone in the booth can get that photo and put it up, I read it in my mind.
We're gonna find it. We'll put it up. So Andrew, this is our special shout out to you because I saw you're actually sitting at home tonight, single and eating macaroni and cheese and kielbasa's. I don't know what they are. Sausage, some sort.
The bats are back.
The bats?
For the Stros.
Oh yeah, for sure. 12-1 last night.
I've been following since I started losing so many games.
Well, they got him back last night.
That's good.
Yeah,
That's good.
Yeah, it's about time.
Is it the type of juice they're running?
What do you mean?
Did they take a hit? They're bringing people in that's causing uproars.
Well, we'll talk about that later in the show. We'll get to that. I mean, that's a good point. I mean, there is the theory that they brought in Roberto Osuna, and the whole domestic violence thing has caused some upheaval in the clubhouse. But we're going to talk about that a little later in the show. We're going to open up the phone line, 713-807-1794, probably about halfway through the program. You can also tweet us at HCCLA_TV for any questions and comments you may have. But I want to start first, guys, with the Paul Manafort trial that's going on. We talked a little bit about it last week with our guest, but now this week we finished the government's case. The defense decided to rest. They did not put on a case. Manafort elected not to testify. There was an exchange, as most of us have normally seen in front of the judge, where he went on the record as the prevention of the writ later on down the road, saying, no, I wanted to testify, but my lawyers wouldn't let me, where the judge questioned him about whether he wanted to testify. He made it clear he did not want to testify. They then went to closing arguments. The case went to the jury today, and we got four notes, or 4 questions, I should say. 1 note, 4 questions on the note. But I want to start, guys. So the defense rests. They didn't put on a case. They went very hard at Rick Gates, the cooperating witness, and their whole closing argument. And I want to touch on kind of a bunch of different things because we've all tried cases. We've all been in the heat of the battle. We've all had to make these decisions. And so there's a couple different things. First one I want to touch on is Gates. He was the main cooperating witness for the government, the snitch, if you will. He was actually charged first, and then it was a two defendant indictment, Manafort and Gates. And at some point down the road, Gates cut a deal with the government. Now, his deal was capped at 10 years, and it really gave some outs to get really a lot lower sentence than the 10-year cap. So one of the questions going around today that I saw, which was a very good point, was did the special counsel give Gates too sweet of a deal?
Well, Jimmy, you know, the special counsel certainly gave Gates a special deal. And that is not a deal in tens of thousands of cases across the United States in federal court. That is not a deal that you see.
No.
That is not a cap that you see. That is not a commitment you see from the prosecution. Because they don't need somebody to do it. And here they needed Gates.
Do you think they really needed Gates? I mean,
Well,
the argument that they've made all along, the government's made, it's all in the documents.
I think the government created a situation where they portrayed that Gates was a necessary witness. And that was maybe a flaw in their own strategy. Every story has a villain, and the defense's position appears to be that Gates is the villain, and that's whether that's true or not, the government created that opportunity for the defense in this case.
So when someone says the defense didn't put on a case, they just really did through their cross and through their themes and opens and closings.
You know, Julio, and that goes to this perception that the defense should put on their own evidence. And that's just not right. And it's not what the Constitution says. It's not what the federal rules say. And it's not really, when you boil it down, what our common sense says. Either the government proves its case or they don't. And it is a valid defense, a valid affirmative defense to challenge the government's case when they put it on and then say nothing.
And the reality is, I mean, I would say 90% of the cases that we try, probably somewhere between 90 and 95% of the cases we try, we don't put on a case.
Well, yeah, absolutely. I mean, you never want to expose something that you don't have to expose. And when you see what the government is putting on, and a lot of the times in these fraud cases, especially bank fraud cases, which essentially what this 18-count indictment was, it's primarily a bank fraud case, they start out their whole entire argument that all you have to do is follow the money. And clearly the government here had some issue with respect to just following the money, because they
wanted you to follow the ostrich jackets.
And they wanted you to follow where every penny was spent, right? And so they bring in this witness, Gates, and they heavily rely on him in order to kind of close in the gap. So I think the defense strategy here with respect to heavily crossing Gates in order to expose something that ultimately leads the jury to believe that something isn't right here is probably the right approach. But the interesting aspect here of the whole entire Manafort not choosing to testify and not choosing to put on any case at all actually really comes down to him maybe possibly hoping for a pardon down the road.
True, that has been speculated a lot. He obviously still has to get through the Washington, D.C. trial as well before any of that can occur. Julio, a thought has crossed your mind.
What are some risks of a defense putting on a case, in your opinion?
Well, the risk is that you create a narrative that the public doesn't agree with. I mean, right now the narrative seems to be, Trump versus the special counsel. That's the prevailing narrative if you look at it from 30,000 feet.
Well, it's interesting you point that out, because remember there was a motion in limine to prevent any mention of that. But the defense got it in closing argument. And really it was objected to, but you can't unring that bell. So tactically speaking, I think that was a smart move by the defense. Like, hey, what's really going to happen to us if we violate this? We can't get reversed on appeal for violating it. The government could, but I mean, they're not going to get reversed on appeal, because if there's an acquittal, there's no appeal.
So the defense strategy, I think, is to try this case as a referendum on the special counsel.
I agree. I mean, that's where this has been going.
And it's a smart move on the defense's end. And Sean and I had recently tried a case that was fairly complicated with a lot of political aspects and many of the nuances that this case possibly had. And we were limited in many ways on addressing certain political issues or issues that exist in Washington. And what we did was we employed a strategy where we ultimately slowly started to leak that in, because we wanted the jury to understand that this is much bigger than just a simple fraud case. And so what the strategy here was is ultimately, play this to the end and allow it ultimately to come in. And I think that the questions that the jurors had today possibly very much, relied on what the defense ultimately did.
Yeah, let's talk about them. I mean, one of them is a technical question about whether if a person is required to file if they own less than 50% of the company. I mean, they're clearly looking at technicalities here. Define a shelf company. The big one that came out was redefine reasonable doubt. Now, in federal court, you actually get a definition of reasonable doubt, and they were clearly given that definition in their jury instructions by the judge, and now they want it redefined.
What that suggests to me, Jimmy, is that, and you may agree or not, but there's somebody on that jury who has defined reasonable doubt in a way that some other jurors are taking exception to. And so that has become a dispute point within that jury room.
Yeah, it's for me, here's the thing about jury deliberations. I have come to the point after the last trial that I tried this year that we have no clue what these people are thinking. We really don't. We can sit here and say, well, the jury must be thinking this. They must be doing that. Somebody in there must be thinking this. But really, we don't know. We're full of crap. We're just speculating. I mean, we really don't know what these 12 strangers are thinking. They're thinking something, and they've got questions. They're sending it out, and I mean, it's just really hard to know what they're thinking. And for me, it's like, this is the most, as you guys well know, I mean, it's the time where you get a question like, redefine reasonable doubt. You're like, they are totally questioning the government's case, and then 10 minutes later they come out with a verdict, and it's just like, oh.
Right. There could have been one guy just sitting there, I just don't understand the definition. Can somebody just please explain it? And he's just not getting it. Exactly.
There's an old story about the legendary trial lawyer in Houston, Percy Foreman, who had a client during deliberations who was constantly at him, what do you think they're thinking? What do you think they're doing? And Percy's response, very contemptuously toward the client, was, look, trying to figure out what a jury's doing is looking at monkey dung to try to figure out what the monkey ate. And I think that's a fair analogy or a metaphor.
It's pretty close.
And I don't think that Percy actually used the word dung.
No, I think it was a little stronger,
right.
Stronger language than that.
So this jury acquits. What does it do? What does it do for Trump? What does it do for the United States? What does it do for this whole investigation in Russia?
Well, if the jury acquits, I think Trump can fire Mueller.
Well, look, I think he could do it anyway, because as I read at some point this week, and I didn't catch the distinction at first until I read this. He's special counsel. He's not independent counsel. So he is actually in the Justice Department. He's not like Ken Starr. People are trying to equate him and Ken Starr. They're not equal. He is a special counsel. He is a subordinate of Rod Rosenstein because Sessions has recused himself. And so the article I was reading was in the context of whether or not he can subpoena the president. Well, can somebody within the executive branch subpoena their boss? Because that's essentially what the president is.
Well, I just want to address really quick, what does this do for the country? I think that's a very interesting topic. The challenge here is that I think the media is very much driving the Russia investigation train because they want to be able to put this as a front story on every single page of the news, right? And so with Manafort potentially being found not guilty in this kind of case, I mean, yes, Trump is going to play it up, but the media is just going to try to latch on to something else in order to say, they're going to go back to the whole entire inference that this has nothing to do with the Russia investigation. This was just, a case that it was all about Manafort. It was all about his, wrong deeds in Ukraine and his ties to some Russian oligarchs. But ultimately, he was tried, and we were going to try him anyway, regardless of this Russia investigation. That's how it's going to get spun. They're going to try to shut Trump's claims down as much as they can.
On the heels of people losing credentials, the people acquit.
And I think there's an interesting point to be made, though, that there are people throughout our country and many prominent people who are salivating to stick it to President Trump.
Absolutely.
For deep-rooted reasons that are very emotional. But what we've created here is an apparatus to do that. Special Counsel Mueller. And what I think we should all be very wary of as a country, including those of us, not us meaning that I think this way necessarily or not, but people who want to get President Trump, is the apparatus and the tool to do that more dangerous than President Trump? And do we want to really unleash something like this into our domain?
Well, it's a fair point because, I mean, you know, is this a prosecution that was made out of something that you normally wouldn't have? I mean, this, you know, would Paul Manafort have gotten prosecuted but for his ties to Trump? I can't say that he would have.
And do we want to allow these free-reigning prosecution machines to operate within our country independently of the political process?
Yeah.
Absolutely not.
Well, I mean, and we all know
Absolutely
cases. We all know cases, and people don't want to acknowledge this publicly, but there are people who have done probably far worse than Manafort, who have never been prosecuted.
Oh, absolutely.
I
Absolutely.
mean, we've represented some of them.
Well,
And for whatever reason, the authorities just decide we're going to take a pass on that one.
yeah, they're going to look the other way. I mean, look, this is all a timing thing, and we know that. And with respect to Manafort, whether or not he would have ultimately gone to trial or even been indicted, I mean, there's no telling. You know, his story is just so compelling and so interesting. I mean, this is a John Grisham novel, as good as it gets. You know, and he's been around since the '80s, and this is the kind of guy that's been in the public, kind of in the background in the public for a long time, and he's been hiding his persona, and he's the kind of individual that makes a lot of money and loses a lot of money, and ultimately what happens to those people is they find themselves on the wrong side of the law, which he did, and he may have done some of this stuff. The question is ultimately was what he had done so egregious to the point to where we want to pursue him, and we want to pursue him vigorously, and we want to expose all of this, and we want to make this whole entire media hoopla? Likely not. I mean, if Trump was never elected and he was never president, I don't see this case being so publicly.
Well, if he had never gotten elected, I mean, this case never would have been prosecuted.
What's the guidelines on him?
I haven't run the guidelines, but I mean, you got to figure they're, with the amount of money involved that we're talking about,
He'll be there
they're
forever.
high. Yeah, I mean, he's 69 years old.
He'll die in prison.
Any conviction, and that's the strange thing. So, you know, oftentimes I've seen multi-question notes come out, and with questions like this, what does this mean within the context of reasonable doubt, and define certain things, and you know what happens? They acquit your client of some counts, thinking they're doing you a favor, and then convict your client of counts that it's like, well, wait a second, how did you convict him of that, but acquit him? Well, it makes no sense, and it's just that's what I'm saying is, when you see results like that, you go, I give up. I give up. I am not going to predict what these people are thinking anymore.
You know, this is a metaphor for a wild game hunt.
Yeah.
You know, Manafort is a zebra.
Ostrich.
Or an ostrich. And you know, you got Gates in there he's been hit, but he's some kind of gazelle. Yeah. And you got Trump there, the lion, who they're really after. I mean, it's just, when you boil it down metaphorically, it becomes just an absurd sporting event.
But you know what this reminds me of, kind of in a way, too? If in fact our speculation is correct, it's possible that they could be looking at this much like they look at the juries in South Texas look at cartel cases, where you end up with a ton of mistrials on major cartel-related cases, because everybody around there is like, they're prosecuting the mule. The mule?
Right. The driver?
The driver?
What?
Just drove the truck?
Right.
Like, no.
You think they tried again?
Huh?
Did they hang him up? They try the case again?
No, look, a hung jury's a loss for this.
That would
A hung jury is a loss.
National press lose.
They'll find a way to settle it to get it out of the way.
Yeah, because look, they can't have, at this point, Gates has already he's had his head lopped off.
They've hyped this thing up all over. NPR every morning.
Yeah.
And the government's kicking butt, and the government is taking them down.
And guess who's not getting a pardon? Gates.
No kidding.
So he's blown that deal.
Right. Yeah. So I mean, if there's a mistrial, if there is one holdout who's saying, I don't understand reasonable doubt, and they're back there going, look here, dummy, read it. This is what it says, plain English. And he just holds out and says, he or she holds out and says, I'm not doing it. Then you got a hung jury. Now, even if it's of 11-1 for conviction on all counts, I still think the special counsel is going to have egg on its face.
Oh yes.
That they couldn't convince all 12 to do it.
Right.
In most cases, an 11-1 verdict would mean they're trying that case again. I'm not so sure
In this particular
in
one.
this particular case that if they get 11-1 for guilty, that they'd retry it.
And you know, for the viewers out there that don't typically do federal cases or are not aware, you know, when there's multiple fraud counts like this, and we're talking, you know, more than 15, I think, are bank fraud counts. If the jury is thinking they're doing you a favor by finding you not guilty on a few of these because it's going to minimize the ultimate sentence, you know, they're very, very wrong. The reality behind it is all it takes is one of those fraud counts to hit.
Well, and see, I'm glad you said that, because they're instructed that they're not supposed to consider punishment.
Right.
But you got, again, don't know what they're thinking, but the only rational way for us to look at it is they got to think they're trying to do us a favor on sentencing.
Right.
Even though they're not supposed to contemplate sentencing.
And in the context of a federal case, they don't know what sentencing is,
Right.
and they don't understand what it's going to look like.
We got a call coming in. Let's hit over to the phone lines and see what's going on over there. Hello, thanks for calling Reasonable Doubt.
Yeah, hi, thanks for taking the call. I just want to take an issue with alleging that the prosecution is politically motivated. I think that, if anything, the politics that come into this is someone like Paul Manafort, who's been doing this kind of stuff for however long he's been doing it, choosing to propel himself into the political spotlight by becoming the chairman of the campaign for Donald Trump. If he knows what he's done, he knows that he's going to be scrutinized very closely and very heavily. That doesn't necessarily mean, because he took that position, that doesn't necessarily mean that he invited politically motivated prosecution on him. He kind of if he's been doing this stuff, he kind of invites this on himself by putting himself in the spotlight.
If he loses, dude gets fired. He deserves to get fired. If he loses, the guy's gone.
The arguments that y'all were making earlier that this was politically motivated prosecution and that this whole thing never would have happened if he hadn't been the campaign chairman for Donald Trump because people don't like Donald Trump. I think that you're correct that this may not have come to light if he had not been the campaign manager for Donald Trump, but that's not, he's not being prosecuted because of that. He's being prosecuted because him being propelled in the spotlight put all of his financial dealings under scrutiny.
Well, I agree and disagree with you. I mean, I think, and it's fair points, but I mean, look, the reality is I don't think when we say political prosecution, they've made the U.S. attorney's offices, the Department of Justice, they have a far wider discretion than local state prosecutors do in deciding what cases to take and what cases they're going to go after. Okay, this special counsel was formed for the purpose of investigating Russian collusion. As the judge noted, they went after other things to try and put pressure on people, hoping that they would plead and provide information. That is not an unusual tactic. I don't fault them for that, because I mean,
it's very common, right?
No, it is, and believe me, I've had clients who have gotten ensnared where they would go and conduct a raid on a business for what that business was doing, and they go into the CFO's files and say, well, what the heck is going on here? There's the CFO's running a fraud with another guy out over here. Well, and that guy gets wrapped up.
There's actually proof in the pudding that this is politically motivated. And look, I'm not a Republican, so I'm trying to see this as objectively as possible. But here's the proof of it. If this was not politically motivated, when they got the stuff on Manafort, they would have referred it to the local AUSAs.
Yes.
Instead of spending probably what will turn out to be about $50 million of our money to prosecute this under the current special prosecution apparatus, that is probably the clearest evidence that I can tell you is absolutely politically motivated.
Well, and in
I think that's fair. That's fair.
And in addition to that, there's every notion that it's politically motivated from a standpoint of that Manafort was investigated for all of this stuff several years prior to Trump ever running his campaign. And Manafort had knowledge in the forefront that this was coming, that this was a possibility, and he started to prepare for it, and that's why he came back to the United States from the Ukraine, specifically in order to run the Trump campaign, and he was doing it for free. So at that point in time, if he's not prosecuted yet, and all of a sudden is once Trump is ultimately elected, and then this whole entire Russia situation is circling around. I don't know what is more of a politically motivated prosecution.
And I think the thing to keep in mind is that just because we say that, or we assign a political motivation to something, does not mean that we are opposed to it on a philosophical terms. Many of us may feel that the Trump administration is illegitimate or that we have philosophical problems with that.
Right.
But I think there's an overriding concern here that when you create this apparatus, this machinery to prosecute, and it does so in a fashion that seems to be above the normal channels and with funding that is probably unlimited without any checks and balances, that you create an apparatus that can be used not only for the things that you believe it should be used for, but you can turn that turret to someone else who you may not want it to be used against, and you've created a monster.
It's dangerous.
And I mean, the reality is we see
Well, fair point all around. I appreciate y'all letting me make the comment. I'll let y'all get off the show. Please.
Thanks, caller, for
Thank
calling
you.
in.
and the reality is too, politics drives prosecutorial policies. I mean, look what's going on with the immigration. I mean, you want to get right down to it, that's political prosecution. Okay, what's going on, what we're seeing in Harris County with what happened with Arkema and the rise in the environmental prosecutions, that's a political prosecution because and we're not saying they're being prosecuted because of their politics, but that is a political decision. This office has decided for its philosophical reasons and its politics that that's what it's going to go after. You know, to some degree, even on low-level misdemeanors, cops play politics with cases all the time.
Sure.
They let certain people go and don't arrest them for DWI. They don't arrest them for possession of marijuana. Maybe they grew up with them in their entire life and they make the decision, you know what, I'm going to give that person a pass. I'm not going to take them in. Or that's so-and-so's kid. I'll give them a good scare, but I ain't going to let them go in. Happens all the time, okay? And all of those have political undertones to them, okay? To say that justice is truly blind, I think, is just a misnomer and really a farce, to be quite honest, because justice is what the people in the power want it to be.
Like a Waco disaster.
Exactly.
I hear those cases are starting to fall like flies.
Well, there's one step for trial that got continued today. You know, the last question that I wanted that the jury sent out before I want to go on to our next topic is they said, can the exhibit list be amended to include the indictment? Now, the interesting thing is the indictment obviously is not evidence. And like in state court, they don't send the indictment back. But in federal court, especially here in the Southern District, the judges routinely send the indictment back to the jury.
I had no idea.
Yeah.
Yes.
And even over your objection. I mean, you could object and say, Judge, it's not evidence. It shouldn't go back there. No, I send the indictment back all the time.
One of the problems with that is that if you look at the federal charges in the abstract, without the indictment, sometimes the charge is a little bit loose and confusing. And so the judges, I think, intend the indictment to inform the charge, but what I think it really does is dilutes the charge and distracts from it.
Now, the funny thing is sometimes sending the indictment back can work to your advantage when the prosecutor's narrative in the indictment is way different from what the facts were at a trial. You know, so sometimes it can be an advantage to you.
Well, I'd like to know what the answer to that question was, because I certainly do not think that the judge or the indictment could possibly be amended as part of the exhibit list. I mean,
I don't think it can
either. I
either.
would see that as a
I don't
huge
think
problem.
Well, how are they sending them back? Like you said, in your experience in federal and then in your federal jury trials, you say that it's routinely sent back. Is it sent back as not as an exhibit, but as a?
It's sent as a demonstrative piece of evidence that's just there for them to look at and to take inference from. And ultimately, what ends up happening is they follow the indictment and they read the indictment as though if that is the case, instead of following what came out during the course of the case and ultimately what the exhibits showed. And as Sean explained, you know, the charge itself is what the jury should be following, and ultimately they end up sitting there sifting through this indictment and said, well, I think this may have happened, and I think this may have happened, so he's probably guilty of these particular counts.
Are you all surprised at how fast it went?
The Manafort trial? No. In fact, I think it took longer than I expected.
Really?
Yeah, I think they did a good job at slowing the freight train.
6 days or so? 5 or 6?
This is not a complex case.
No, it's not.
This is a
There
case
wasn't many-
that
there wasn't a lot of witnesses.
Well, I thought he had bank accounts all over the world, and he had these accountants and CPAs who were doing things, and then this other guy who's snitching is around. 6 days.
I think that's a reasonable amount of time to try that case.
I think the government did that on purpose. I don't think the government wanted to overexpand on exhausting jurors with an abundance of financial records that's ultimately going to just exhaust the process of them deliberating this case. What they wanted to do is show, look, here's what happened, here's the money trail, here's Gates coming in here to say that this guy's a total fraudster, and we want you to find him guilty. And they think that that could get him there. That may ultimately be a problem for them, so we'll wait and see.
Did they argue this morning, or was it the charge conference?
They argued yesterday.
Yesterday. Oh, and then did the jury go back and deliberate at the end of the day? Because I thought it was like they got it this morning or something like
No,
that.
well, they came back this morning and started deliberating.
To start.
Yeah. So they did closings yesterday.
Phenomenal. What's the what 30-minute closing, hour-long closing?
Oh, I don't know what it was. I'm sure he probably gave them both sides probably an hour.
What's
think.
the longest close you've ever done?
I try to keep mine short. The longest I've ever done is about maybe an hour in a complex fraud case.
What about you?
Well, I mean, the longest I've ever done for a closing is probably about 30 to 45 minutes.
Yeah.
And that was, I thought it was way too long. I mean, frankly, I think that the longer you go on, the less the jury starts to pay attention to you. And some of your points get really lost. And I find that, and look, I've only been doing this for 15 years, so I'm by no means declare myself an expert on this. They call it the practice of law for a reason. They're always trying to get better, right? But I have found that the strategy employed by a lot of lawyers of marshaling evidence in closing arguments is not an effective one. And a lot of lawyers will sit there and try to put, they'll show documents, they'll show them up on the screen, they'll put them up on an easel, or they'll hold them in their hands, go back and look at this, and they'll go through every piece. I like to pick out, 3 or 4, a main 3 or 4, and say, go back and look at this, go back. These are the 3 main ones you need to look at, because why sit there and go through every piece? Give them the tools they need, but you need to sit there and see, this is the problem. Why? Because you get questions like this. You need to tell them how to use those jury instructions. You need to explain to them what those jury instructions mean, because the odds are the majority of those 12 are not lawyers. So they're reading legalese that they don't understand, and you have to break it down for them. You have to break it down into small words, short sentences, and make them understand, this is your toolbox, this is your hammer, this is your nail, go, okay? I find that's what you have to do. And so I just feel like if you make it short and sweet and to the point, you arm them and give them the tools to go back there in that jury room and acquit your client.
Right. Last thing you want to do is confuse them, right? I mean, so you start out the entire case with a theme, and you want to continue that theme. And this is why this Manafort case would have been so fascinating to try as a defense lawyer, because there's a very, very sexy case to be tried in front of this jury and in front of a potential, and even in front of a voir dire panel, right? To voir dire these jurors on the possible questions and things that could come from this. And you follow that theme through the entire course of the case, and ultimately you want to be able to close this case out with just kind of like, I told you so, this is exactly where this case was going to go, and this is where we are, and this is why he's not guilty. And you don't want to overexpand on it to get, like questions like, hey, what's the definition of reasonable doubt?
Yeah, and the other thing too is going back to the original question, and I want to compare and contrast this case with what we saw this week in Houston, or last week in Houston with the Urson case.
Right.
But Manafort not taking the stand, that is such a dicey call, okay? Because in federal court, more often than not, you are really the client can potentially set them up for a really damaging scenario post-conviction, if God forbid there is one. Because if they get on the stand and testify, even if they tell 100% the truth, at sentencing they can get hit with an obstruction of justice enhancement. And both in state court and in federal court, I think the lawyer has to be very wary, because if you have established some really good appellate issues on the government side, and then you put your client up there to testify, you've likely wiped away all your appellate error.
Particularly regarding sufficiency.
Yeah, because courts of appeals, the Fifth Circuit especially, but here in Texas as well in the state courts, they will say, yeah, that was bad error, but you know what? The jury had the benefit of hearing from the defendant and still convicted.
That goes to marshaling evidence as part of your defense and as to
Right.
whether or not to present one or just to rest behind the state in the hopes that you've woven through your themes and your own stories through cross.
Well, it also, to me, and you know, with the Urson case this past week, he testified not just in guilt, innocence, but in punishment as well. And you know, we were talking before the show. I mean, there was no way you were going to keep that client off the stand
Right.
with a stick of dynamite and a crowbar. You couldn't have done it, right? I mean, you could have knocked him out, and he would have woken up and gotten on the stand. It just, you weren't going to stop him from getting on there, right? But I find too the other issue that you are up against, and this goes also to the heart of putting on a defense case. My philosophy is don't put on a witness unless it actually adds something to your case, because you run the risk at this point of unintentionally shifting the burden.
Right. And I think that there's a conceptual issue there, and that is that if you put on a little bit of evidence, but not much, then the jury starts to weigh the volume rather than the quality or the quantity.
Yeah.
They say, well, they put on more than they did.
Well, and for instance, in Manafort, I mean, look, they destroyed Gates. They destroyed him as a witness. So why would you put your client on to now have it be, who's more credible, the guy that just got assassinated or my client?
Especially if it was
that's what it's going to come down to.
It was the government's witness.
Right.
I mean, especially when it's the government's witness.
Yeah.
There's nothing more than that boils people's blood than a snitch and a bad cop. And you know, so now they're gonna acquit because the government put up a dude who's taking a deal and ready and willing to say anything on the stand.
You know, look, I'm not ready to say they're going to get an acquittal. I mean,
Right.
Look, in federal court. I mean, if they back away from the emotions of this deal and Gates, the liar Gates,
Right.
Could they have made it without him?
I think they could have. I think the judge baited them into calling them.
Based on the evidence, at least that I've heard about and have an opportunity to take not a look at, but just to be aware of, they certainly had a very solid case, especially just on the documents itself and the transfer of funds and money from Ukraine through the connection of Russian oligarchs in this case is not only fascinating, but also extremely incriminating. And, you know, I don't know why they had to muddy the waters with Gates. And this whole entire notion of your client testifying, I mean, as we all know, there's only a few things that the client actually gets to control throughout the course of the case, right? And one of those things, which is the most important aspect of the case, is whether or not they take the stand. And ultimately, the decision is up to them. And I could almost guarantee you 100% that with the Manafort case, there's probably a strategy that they came up with well prior to trial that he's likely not going to take the stand, that they're likely not going to put on a case. But in a lot of these cases, as Sean, you and I know, with the case that we had recently tried, we wanted to see what the government was going to put on first, how these witnesses are going to testify, what are they going to expose, and then ultimately make the decision or assist our client make the decision with what a best strategy to move forward would ultimately be.
Right.
How do you do that? How do you do that? How does your mind process that? Because I know you handled I mean, you've been on the media, you've been on the news, you've handled the biggest of the big in Texas and around the country. How do you handle that?
You just have to do it by the seat of your pants. And you do it with the same instincts that any of us have. There's no magic to it.
How long have you been practicing law?
Going on 20 years.
That's amazing. To the top. And how do you manage your stress?
Well, if you ask my family members, they'd say I don't.
I just asked him before the show, man, you take a break? How do you do? And you still look great, dude.
Well, thank you. I'm going out of the country for a few days tomorrow
That'll work.
to try to decompress.
It's amazing what no-dose and Adderall will do for yeah, you know, I mean, that's one of the, going back to the decision about putting on a case, you know, they had a lot of strategy issues here. They've got the second case coming up, so why would you expose your client to testify in the first case to give them a transcript? Because if you do try that second case, now they've got a sworn transcript of what you said before.
Right.
You know, kind of problematic. But it's, you know, it's interesting because a lot of people are looking at this like, well, if they didn't put on a case, that, you know, it's because it's clear cut. They just don't have anything. You know, it's like, well,
What's reasonable doubt?
yeah.
What's reasonable doubt?
That begs a good question. So there's this new kind of theory about trying cases out there that I want to ask you guys about. And for years, I mean, I think, especially Sean and I grew up under the theory that you better tell a story, because if you're relying upon reasonable doubt, you ain't got nothing. And so you better create a story. And sometimes creating a story can be very difficult to do with some of these cases.
You could lose credibility.
Right, and so there's been kind of in the last couple of years, there's been a new theory out there about how to try a case under the reptile theory, that you just try the case solely on reasonable doubt and put the government to its burden and everything else. And I've read the book, and I've seen. And I've employed some of the tactics, and quite honestly, I don't think you can pull off a pure reasonable doubt. I just don't think you can do it this day and age.
You know, the commentary that I can give on that is, so I practiced and was mentored for years under Dick DeGuerin,
Right.
who's a nationally prominent and successful trial lawyer. And he had a theory, which he never explained to me, but in observation at 30,000 feet, here's what I think it was. It's the best chance of success you have in front of a jury is to propose an alternate hypothesis to the prosecution's theory or the prosecution's narrative, and then promote or provide some evidence to substantiate it, some evidence. And I saw that successful a number of times in places where I thought that the case was hopeless. And there were other times when that theory bombed. For some reason. And so you can never control the universe. There's no universal solution trying cases. But I think I'm very comfortable approaching my trials with the idea that you can propose an alternate hypothesis, offer some evidence of it, and thereby tune into reasonable doubt.
Yeah, I mean, I think you're right, is that if you can come up with a story that makes sense, that the tug of war between those two stories in and of itself is reasonable doubt. I mean, I just remember, probably just like you, Sean, it was, I mean, we were preached by Dick and by Dan and by Kent and all those guys, if you're trying this case solely on reasonable doubt, you ain't got nothing. And you know, that's, you got to come up with something, you got to come up with a theme, and you got to start that theme in voir dire, you got to keep it going in opening, keep it going through your cross-examination, and then, you know, if you put on a case, same thing, and then close with it. And now there seems to be this shift along more of what plaintiffs' lawyers have started doing in getting these big verdicts, to try and the theory behind it is that you are trying to protect the criminal defendant from the big bad government. Because I mean that's a real
Ron
struggle.
Swanson.
Right.
I asked people who identifies with, who knows this guy. I just put a picture of Ron Swanson, and the people that say, oh no, that guy knows this guy.
Well,
But
look,
it's real hard to do that, protect from the big bad government, when your client's charged with possession of child pornography.
That's terrible.
yeah, exactly.
You know,
That's
or-
terrible.
or
Those
stuff
are-
like
Right,
that.
it's
I
terrible.
mean,
And the disconnect is a plaintiff's strategy is a prosecution strategy.
exactly.
And there's a disconnect there. And I just think that there has to be some engagement. And as Judge Harmon has said in federal court, in response to these kind of sophisticated arguments about why something should happen without engaging it, you know, was reasonable doubt. Here's reasonable doubt, and here's why you shouldn't convict. Judge Harmon's response is one word: sophistry. And at the end of the day, you've got to have a real-world engagement to juries who don't understand these esoteric concepts. And it's not to say that a jury is not sophisticated, because I think there's a misperception among many lawyers, many of our colleagues, that juries are here to be manipulated, and they're less sophisticated than we are, and we're the ones, you know, pulling the strings. And I don't think that's true.
Yeah, it's an interesting concept, and you know, and you mentioned Kent, for instance, and I worked for Kent Schaefer for quite some time, and he he certainly hit home the notion of creating the theme throughout the course of a case, and that's important. It also goes back to your point that you talked about. You don't want to lose a jury on not putting on anything at all, right? And this concept is very dangerous, partially because it can't possibly work on every type of case, right? You're going to come across all types of cases. You mentioned a child sex case. I mean, just to go in there with, or a child pornography case, my apologies, just to go in there with,
either one.
Reasonable doubt. Frankly. Well, either one, obviously, but with specifically, let's take for example a possession of child pornography case where they bring in all evidence with all kinds of forensics and computer technology, and they put on all types of stuff in front of the jury. You're just going to be arguing beyond a reasonable doubt. It's quite problematic in that kind of context. So I think it's a very dangerous type of theory to attach to, but at the same time, I think that there's a combination of things that you can do throughout the course of a case, which you can employ that theory. Some of it, maybe use 75% of your case to say, I'm going to go with beyond a reasonable doubt, and put a little bit of your own kind of theme on the case as the other 25%. I think that might be an effective strategy in a lot of these cases.
Yeah, I think so. I mean, you've got to come up with I think in a pornography case, you're almost relying upon finding some sort of technical, aspect of did somebody else put this on my computer?
An alternate perpetrator.
Right. Yeah, exactly. The Shaggy defense. It wasn't me.
That's awesome. The other thing is, when you have maybe one or two more strikes, you already know half the jury is terrible. You're sitting on a terrible case. Half the jury is gonna be terrible for you, and now you're really looking like the best thing we can do is hang this up and get it and try this again. Every now and then I like to do this play. I say, okay, and I rank everybody. We have independent scoring for every question and everything that we do. I say, usually pretty early we can identify the wild ones we just put to the side or make a little note. And I say, that's the guy I need in the jury. Mm-hmm. So, prosecution, the jury's terrible for us on 6. They're good 5 for us. And we know we're never going to move these people just based off the jury selection. And we say, where's number 11? Bring number 11 in. And we'll hope that when the strikes come out, he ends up. And that one individual on the jury, that one that writes the damn note, tell me what reasonable doubt means.
Well,
the dude.
You're all looking for that guy in jury selection, your juror, to try the case to. Mm-hmm. You're trying to find. That's what voir dire is all about. Because frankly, it's very difficult to get 12 people to agree, right? So if you can just get one of them to hold out for you, that's what you need.
I've developed an interesting theory about voir dire, and I don't know if it's supported by empirical science or anything, but it's worked for me.
Or a long night of heavy drinking.
Yeah, that's probably what it is. But in state court in particular, I found it to have a thread of success, and that is that I don't really use voir dire as an opportunity to expose. I use it as an opportunity to teach and to start to inculcate my viewpoint into the panel before my opening statement. Because I have found that if I expose the issues and start to extract too much response, then I'm exposing the friendly jurors to strikes. And all I'm doing is getting rid of a few poison pills who would become evident anyway.
Right.
But this is an opportunity for me to begin to give my opening statement.
Yeah, I mean, that's the way you gotta you have to look at it.
Do you use PowerPoint in your voir dire?
No, I just talk to the individual because I want to create an interpersonal dynamic where I'm just a guy here to defend my client.
Are you talking to, how large is your panel, and are you eventually talking to one-on-one?
The first thing that I do to kind of break the ice is by the time I get to my voir dire as a defense lawyer, the prosecutor and the judge have both had theirs, and they go on, they always will, and they do it every time. We're here to select a fair and impartial jury. So I get up and I say, look, I need to be honest with you about something. Both the judge and Mr. Smith have informed you that they're here to select a fair and impartial jury. And I have to tell you that that's not why I'm here. There are issues and ideas that are very important to this case. And those are ideas that I want to find, those of you who identify with those issues and ideas are important jurors to me. So I'm not looking for a fair and impartial jury. I'm looking for a jury of people who will identify to the issues that we think are important to this case.
Can you give that's fascinating. Can you give an example of something like that?
Self-defense. The idea, for example, that a person has the right to shoot someone who comes into their house at night. Believe it or not, in Texas, not everyone feels that way. Not everyone feels that if someone breaks into your car or opens the door while you're in it, or your wife is in her car at night by herself, that she can't open fire on that person. But that's the law.
Well, those people are just wrong.
Right. I think they're wrong, certainly under Texas law, but
Just for living in Texas, you're wrong.
what you can do really in the right case, particularly cases in self-defense, even murder cases, is you can really get a coalition started in Vordire where people are angry about the fact that somebody's disputing this. And I found that to be a very effective tool, is to start coalition building early on, right out of the gate. Instead of this kind of more academic exercise of identifying people who are good so that you can keep them, which doesn't work, and identifying people who are bad who you can strike them, which is only of marginal benefit.
Speaking of self-defense, the Denny's guy is getting murdered again, charged with murder, isn't he? They're going to retry that. With the chokehold, they're going to go, and it said he was going to be charged with murder.
Yeah.
Again.
Doesn't surprise me. I want to try to get, so we got a little bit of time left here, so I want to make sure we have enough time to talk about the last thing I wanted to get to with you guys, and that is, we mentioned at the top of the show about with the Astros and the slump they were in, and there's been a lot of people speculating that, the acquisition of Roberto Osuna, the pitcher, who recently served a 75-game suspension for under the league's the Major League Baseball's domestic abuse policy. He was charged with domestic abuse. Rather than fight the case, he took the 75-game suspension very early on. He did not even contest it with Major League Baseball. The Astros made the trade, I don't know, about 5 days before he was to become eligible to play again, once the 75 games suspension was done. Huge uproar online because the Astros had a no-tolerance policy. Is what they said, no tolerance to domestic violence. Many of the fans and media felt that they were going back on their word by doing this solely because he accepted the suspension. That the suspension in their mind was tacit to an admission, and he has not even made a court appearance yet in Toronto. My understanding is that nobody has even really seen, not even his own lawyer, I don't think, much of the evidence yet. The evidence is still being produced. So I wonder where people are coming to this conclusion. And I'm not saying he did it or he didn't do it. I'm not making that presumption at all. And in fact, I mean, his lawyer is saying, look, this is going to work out for what in Canada they call peace bond, and it seems to be some form, as best my research can tell. And I'm no Canadian lawyer, but me trying to interpret what Canadian law, peace bond is kind of the equivalent here of a pretrial diversion. And, that's, you're not admitting, you're not denying, you're just saying, hey, go do some community service and we're done here, kind of thing. So I view there to be a huge rush to judgment on this. I'm not saying it's factually they're wrong or they're right, but they certainly don't have the facts to be making that judgment yet.
It's a huge rush to judgment, and a lot of it, and if you think about it, on a lot of cases that end up in the media, for example, and we scroll down on the Chronicle or on Yahoo and we start looking at comments, right, from individuals that are just reading these articles and they're like, oh, send him to the fryer and he's guilty, guilty, guilty. And, the reality behind it, and you brought up pretrial diversions or trying to address a case without it actually moving through the court system, right? When you have an individual as high profile as he may be, and you tell him, look, something may have transpired here, right? And we're not telling you that what they're accusing you of has transpired, but you may want to do some anger management, and you may want to do something in order to just kind of, stop this notion of what actually happened, right? And this may all just kind of go away. And by him saying, I'm going to take this suspension in order to avoid a potential prosecution, take some type of responsibility for what had occurred in my own household, was, in his opinion, the right way to handle this.
Yeah.
And I think that the public in this particular case may be jumping to a conclusion, unlike a lot of these other cases that we've seen that are high profile, specifically with athletes, where, you know, unfortunately some of them have been caught on video, and some of them are very clearly, you know, long-term domestic violence cases where some may not have even been punished, you know, severely enough. This one is specifically kind of a bad example of what this is all about.
Well, and you know, a lot of people were saying Osuna should never have played. They did the same thing with Ezekiel Elliott. They're doing the same thing with Urban Meyer up in Ohio State, saying that he should be fired for covering up domestic violence, when I think, based upon what I'm seeing, is he may have actually reported it to the higher-ups at Ohio State. And what they're trying to get him on is that he denied it in the Big Ten media conference this year. So, but looking at most of what our clients go through, the non-celebrity clients, what they go through in this, there are people every day charged with domestic violence down at this courthouse, at the Fort Bend County Courthouse, the Brazoria County Courthouse, the Montgomery County Courthouse, all around the country. They're not celebrities. Nobody's saying that they should never work again, that they shouldn't have their job.
And what's interesting about that, and I think this tunes into both what you're saying, Jimmy, and what Gary said, I've been doing this almost 20 years, and I've tried a number of domestic violence cases, and I've resolved or settled a bunch more. And if I had to quantify the number of them that turned out to be frivolous, I would probably put that at about 60 to 70% of cases that are filed as domestic cases that shouldn't have been filed at all.
Yeah.
And I think it's very significant because I can extrapolate that over a large number of cases. But to say that just being filed on for domestic violence is an indicator of anything is just wrong. These are flimsy cases categorically.
But do you guys think we're going to see, given the just outcry we're having against celebrities on these cases, do you think that is going to start to trickle down to people in everyday life? I mean, is it going to be something that if you get arrested for domestic violence, that you're going to lose your job at insert company X?
Well,
right here?
Certainly what it does is it communicates and telegraphs to people who are interested in exploiting the legal system to obtain an advantage or leverage that, hey, this is an opportunity for me to make a certain type of allegation that will have a devastating effect and that will give me the result that I want.
You know, it's interesting, and I don't think that a panel of 4 men should probably be discussing the Me Too movement, but I think
3 white dudes and a Mexican can handle this.
Hey, vato!
I think that the Me Too movement has had a very interesting dynamic to how these cases are now approached, right? And not only in the media, but also in our local district attorney's offices and also in companies that are realizing, you know, they have employees that they need to deal with, and they're restructuring the way that they handle these situations where they find out an individual has now been prosecuted for this before they've even, you know, gone through the court process. They already have HR reaching out to them, telling them, tying their hands behind their back, telling them, look, here's what's going to happen now. So it's a really interesting situation of how it's all moving forward right now.
It is. I want to get you guys back to talk about it again because we ran a little over on some of the other subjects, but I do want to delve into that because I think it really is a lot of questions that that I would like you guys to send me your feedback on Facebook, Twitter, wherever you can find us. But that's all the time we have for this week, ladies and gentlemen. For my co-host, Julio Vela, and my guests, Sean Buckley and Gary Tabakman, we thank you for joining in, and we'll see you next week. Good night.